Hi guys, welcome to Chapter 10, Probation, Parole, and Intermediate Sanctions. So we're going to be talking more about community corrections and those things that we do outside of incarceration. So why do we need community corrections? When we talk about this term community corrections, we're referring to the correctional supervision of offenders in the community as an alternative to sending them to prison or jail. And community corrections can be probation or parole, and it's often considered less severe and therefore a less worthy alternative to imprisonment. So we're talking about justifications for community corrections. And with reintegration, we're really referring to the goal of corrections that focuses on preparing the offender for a return to the community. And that's going to be, when they have no further criminal behavior. An offender is generally considered to be rehabilitated when he or she no longer represents a threat to other members of the community and therefore is believed to be fit to live in that community. Now, with diversion, this refers to an effort to keep offenders out of prison or jail by diverting them into programs that promote treatment and rehabilitation rather than punishment. And diversion programs not only relieve the pressure on overloaded courts and overcrowded jails and prisons, but also spare low-risk, nonviolent offenders the collateral consequences of a conviction. So many politicians and criminal justice officials who do not look favorably on such ideas, such as reintegration and diversion, have started to embrace these programs to keep nonviolent offenders out of prison. And the reason is that community corrections offer enticing financial alternatives to imprisonment. Now, how does probation work? Now, probation is the most common form of punishment in the United States. Probation can be generally defined as the legal status of an offender who, after being convicted of a crime, has been directed by the sentencing court to remain in the community under the supervision of a probation service for a designated period of time. And that's going to be subject to certain conditions that are imposed by the courts. Now, in traditional probation, the offender agrees to comply with certain terms for a specified amount of time in return for serving the sentence within the community. So one of the primary benefits for the offender, besides not being sent to a correctional facility, is that the length of the probationary period is usually considerably shorter than the length of a prison term. And the traditional form of probation is not the only arrangement that can be made. A judge can hand down a suspended sentence, which is a judicially imposed condition in which an offender is not required to begin serving his or her prison time immediately after being sentenced. So that brings us to alternative sentencing arrangements. So there's some different things that happen with this. Judges can combine probation with incarceration, and some of these options might be split sentences. And with split sentences, this is known as split sentence probation or shock probation. The offender is sentenced to a specific amount of time in prison or jail, and then that time will be followed by a period of probation. Shock incarceration is an arrangement where an offender is sentenced to prison or jail with the understanding that after that period of time, he or she may petition the court to be released on probation. And they're going to, look how they did in jail and see what their behavior was like. And intermittent incarceration is where the offender spends a certain amount of time each week, usually during the weekend, in jail or workhouse or other government institutions. So we may see that with someone who, has a good job, has a steady employment, and maybe they can do their time on the weekends. So generally, research has shown that offenders are most likely to be denied probation if they have multiple charges, convicted maybe on multiple charges. Were they on probation or parole at the time of the arrest? If they have 2 or more prior convictions, maybe they're addicted to narcotics. And that's not going to go away with any sort of intervention. Did they seriously injure the victim of the crime, or was there a weapon used during the commission of the crime? So when you get on probation, there's these conditions that will be set, and it's usually on your judgment and sentence. It's almost like a contract. And these conditions can be basically between the judge and the offender. And it's the offender is agreeing that he or she will follow these terms. And if you don't follow the terms, they may be revoked. And revocation is a process that happens, revocation hearings. And this is where probation is ended and the probationer is punished for his or her wrongdoing. And that's often by being sent to jail or prison for the original term, which has been decided by the court. So with principles of probation, first, the conditions must be related to the dual purposes of probation, which most federal and state courts define as 1, the rehabilitation of the probationer, and the protection of the community. Second, the conditions must not violate the U.S. Constitution, obviously. Probationers are generally entitled to the same constitutional rights as other prisoners. Probationers do not give up certain constitutional rights when they consent to the terms of probation. Now, most probationers, for example, agree to spot checks of their homes for contraband, such as drugs or weapons, or they have to really understand that they have a diminished expectation of privacy when you're on probation. So some conditions that may be imposed, we'll look at them into different categories. So they're going to fall into standard conditions. These are basically just going to be standard ones that are imposed on all probationers. So these include, regular reporting to your probation officer, notifying the agency of any changes of address, not leaving jurisdiction without permission, and, keeping a job or going to school. Punitive conditions usually reflect the seriousness of the offense, and they're more intended to increase the punishment. This might be fines, community service, restitution, drug testing, maybe going to classes, home confinement, electronic monitoring. So those are more punitive in nature. And then treatment conditions can be imposed to reverse patterns of self-destructive behavior. So this might be drug and alcohol abuse, anger management, sex offender treatment, mental health treatment. Approximately 27% of probation sentences in this country are going to have some sort of treatment conditions. So the probation officer has the following roles. They may set in to use their authority so that they can do revocations. And so I want to make sure. Before we get into the revocation, I want to make sure that you guys understand that probation officers are really relying on their authority to guide the offender to get through the sentence. So even the most balanced, firm, but fair approach to probation can be defeated because of excessive caseloads. And so caseloads is a number of clients that the probation officer is responsible for overseeing. Of course, if your caseload is too high, that probably means that you're going to have a hard time keeping track of those on your caseload. So probation can end in one of the following 2 ways. So either the probationer successfully fulfills all the conditions of the sentence, or the probationer misbehaves and the probation is revoked, and that's where they will be sent to jail. So the decision of whether to revoke after technical violations, such as failing to report a change of address or testing positive for drug use, is often made at the discretion of the probation officer. So in a few court cases, these became set some case law. So in Mempo v. Ray, this was in 1967, the court ruled that probationers were entitled to an attorney during the revocation process. And in Morrissey v. Brewer, 1972, and Gagnon versus Scarpelli, 1973, the court established a three-stage procedure by which the limited due process rights of probationers must be protected in potential revocation situations. So at first there's this preliminary hearing, and this is an appearance before a disinterested person, so often a judge, and the facts of the violation or the arrest are presented, and it is determined whether probable cause for revoking the probation exists. This hearing can actually be waived by the probationer. And then, of course, we have the revocation hearing, and during this hearing, the probation agency presents evidence to support its claim of violation, and the probationer can attempt to refute the evidence. And then the revocation sentencing is if the presiding body rules against the probationer, then the judge must decide whether to impose carceration for what length of time. So does probation work? Specifically, probation and other community correction programs are evaluated by their successes in preventing recidivism, which we know recidivism is the eventual rearrest of the offenders. So there are several risk factors that make a probationer more likely to recidivate, including the following. So if there's antisocial personality patterns that this person has, maybe pro-criminal attitudes or social supports, coming from a family or a friend network where crime is just part of life. Another important risk factor for recidivism includes substance abuse and maybe unemployment as well. So what are the differences between probation and parole? So it's important for you guys to know that parole is not something that is used in the state of Washington. And I think a lot of people believe that we have parole, but we are one of a few states left that do not have parole. So, but I want you guys to know about it. So at any given time, about 870,000 Americans are living in the community on parole or some sort of conditional release. And this is basically where you serve a portion of your sentence and then you're let out on parole. And parole is based on three concepts: grace, contract of consent, and custody. So when you are let out on parole, you have some guidelines that you have to follow. So there is a little bit of a difference when we're talking about the difference between probation and parole. Both of them have kind of the same basic assumption that the offender is going to be in the community serving their time. But the main difference is between these two concepts, which sound very familiar, involve their circumstances. So probation is a sentence handed down by a judge following conviction and does not include incarceration. Parole is a conditional release from prison, and it often occurs after an offender has already served some sort of time in the correctional facility. So parole conditions often mirror probation conditions. All parolees, for example, must comply with the law, and they are generally responsible for reporting to their parole officer at certain intervals. So the frequency of the visits, along with other terms, is spelled out in a parole contract, and that sets out the agreement between the state and the paroled offender. Parole revocation is similar in many aspects to the probation revocation. If the parolee commits a new crime, then the return to prison is very likely. And if, however, the individual commits a technical violation, maybe breaking a condition, the parole authorities have discretion as to whether revocation proceedings should be initiated. Wow, I was way ahead of these, wasn't I? Oh, but this is really good, you guys. I like these two graphics here, and definitely refer to them because there is a difference, and I think people are often confused with the differences. So, what kinds of factors are played in when we talk about the decision to grant parole? So, discretionary release, indeterminate sentencing occurs when the legislature sets a range of punishments for particular crimes, and the judge and the parole board exercise discretion in determining what the actual length of this prison term will be. And for that reason, states with indeterminate sentencing are said to have systems of discretionary release. So, under indeterminate sentencing, parole is not a right, but a privilege. So in Greenholz v. Inmates of the Nebraska Penal and Correctional Complex, 1979, the Supreme Court ruled that inmates do not have a constitutionally protected right to expect parole. Thereby, gives states the freedom to set their own standards for determining parole eligibility. This is why we don't have parole in Washington. So a convict does not apply for parole. Different jurisdictions have different procedures, but in most states that use parole, the parole decision is made by a parole board. And those are members that are generally appointed by the governor. According to the American Correctional Association, the parole board has the following 4 basic roles. Let me make sure. The parole board is going to decide which offenders should be placed on parole. They're going to determine the conditions of parole and aid in the continuing supervision of the parolee. They're also going to then discharge the offender when the conditions of parole have been met. And if there's a violation, they will determine whether parole privileges should be revoked. So looking at this discretionary release basis that we're looking at, and this is what I was talking about earlier. So we're definitely looking at those natures and circumstances of that offender's offense, and then how they were doing on all these other important factors. So this is the parole grant hearing, which again, I apologize, I got a little ahead with my lecture. But this parole board or this subcommittee is who's going to review the information. They're going to meet with the offender. You've probably seen this on TV. There's comments or recommendations from key players. So that will also include the victims. So the victims can be interviewed and say whether they are for or against that offender being released. When parole is decided, there is a number of things that they will look at. Are they a threat to the community? That's a huge piece. They'll look at the nature of the offense and what is their remorse. What has that offender done while they were incarcerated to better themselves? So when we're talking about parole guidelines, nearly 20 states have really moved away from discretionary release systems, and they're more looking at procedures that provide for mandatory release. So under mandatory release, offenders leave prison only when their prison terms have expired, minus, of course, adjustments for good time. No parole board is involved in this type of release, and this is designed to eliminate discretion from the process. So instead, in mandatory release, corrections officials rely on parole guidelines. So let's talk about intermediate sanctions. So what are some different types of intermediate sanctions? Many observers feel that the most widely used sentencing option, which is imprisonment and probation, really fail to reflect the immense diversity of crimes and criminals. Intermediate sanctions provide a number of alternatives and options for wrongdoers who maybe need stricter supervision than probation, but might not be a good candidate for imprisonment, or they feel that imprisonment is unduly harsh or counterproductive. So some categories could be judicially administered sanctions. sanctions that are administered by corrections departments. And let's start with fines, community service, restitution, diversion, pretrial diversion, or forfeiture. So with pretrial diversion programs and forfeiture, these are an alternative to trial in which the offender agrees to participate in a set number of counseling, specified number of counseling or type of counseling in some sort of treatment program. And when they do that, if they follow this and do those conditions, the criminal charges are dropped. We also have problem-solving courts. This might be day reporting centers, or maybe, being put in the community but under intensive supervision. And then, of course, you have shock incarceration, and that's basically putting them in jail, kind of shocks the offender when they see those hardships of imprisonment. And then electronic monitoring is the process that we use when we put someone at home, but we're putting them with a electronic monitoring or EM unit. And this is using technology to keep watch of offenders when they're in the community. There are 3 levels of home monitoring that can occur. Curfew, of course, requires offenders to be in their homes at specified hours, usually at night, because that's where high crime levels happen. Home detention is where an offender is going to remain home at all times. There might be exceptions that are made for education or employment, counseling, or maybe some other activities like grocery store or going to church. And then home incarceration really requires the offender just to remain home. Short of medical emergencies, they have to be home. There's some different types of electric monitoring. According to some reports, inspiration for EM, electronic monitoring, was a Spider-Man comic book in which the hero was trailed by the use of an electronic device on the arm. In 1979, a New Mexico judge named Jack Love, having read that convict, convinced an executive at Honeywell to develop this type of technology. And 2 major types of electronic monitoring grew out of Love's initial concept. First is programmed contact, and that's where the offender is contacted periodically by voice or text, and they have to verify their whereabouts. The second is a continuously signaling device, and that's worn around the convict's wrist, ankle, or neck. And this is a transmitter that sends out a continuous signal to a receiver or dialing point, and that goes out to that offender in their home. And if the receiver device does not detect a signal from the transmitter, there's an information that's provided to a central computer, and the police are then notified. So we're definitely expanding in what we're doing, widening our net when it comes to sanctions. Most of intermediate sanctions are for low-risk offenders, and intermediate sanctions really broaden the reach of the correction system and how far we can go with that and what we can do with having to just lock people up over and over. And with that, we have a greater chance of lowering recidivism. Have a good night.